And we're rolling. Hello and welcome to another edition of Car Brief. I'm Richard Elsager, your host. I'm a licensed attorney in the state of Illinois, practicing in all the courts and jurisdictions of this fine state. My focus area is in personal injury and traffic law and general litigation. I have another sordid little tale to tell you in the automotive world of litigation. This one involves Tesla. They've been in the news quite a bit, more often than not, it seems. This particular little sordid story arises out of the state of Florida. This involved a Tesla driver that lost control of his vehicle and slammed into a palm tree, and he ultimately died as a result. Now, it's uncertain at the base level what the rate of speed was at the time of the accident, but some say, I believe he was going between 75 and 90 miles an hour. I don't have any personal knowledge of that. I can only report on what I've read, but he did slam into a tree and he died. But the big question is, why did he die? Was it as a result of slamming into the tree with the impact, or was there some other cause? Well, let's look into this. And this is a little tale here. This involves a 48-year-old anesthesiologist. So we have a doctor driving a Tesla. And there's some indication from the decedent's lawyer that he bought this vehicle because he was very environmentally conscious and he wanted to drive a vehicle that was what his perception was, that it was well designed, environmentally friendly, and rather sporty. Well, he believed he got that combination when he bought this Tesla Model S. And as he was driving, he lost control, according to the Washington Post. And it wasn't the crash that killed him, but rather what happened was a lithium battery caught on fire. And as a result of the fire, he suffered from smoke inhalation and he suffered severe thermal burns, which the coroner indicated that was the cause of death and not the actual impact. Well, the lithium batteries sometimes do catch fire, as has been known in Teslas. Whether that's a design defect or whether that's just something that's endemic with battery-powered cars, that'll leave to an expert to make that decision. Well, first responders, when they got to the scene, were unable to open the doors. And this is the basis for this lawsuit. The Tesla's doors are a special feature because the door handles are flush with the door panels. If anybody's ever seen a Tesla on the road, and I'm sure most of you have, you'll notice these really cool looking silver metal door handles. They're very thin bars and they're very flush with the door. I think they actually look pretty good. But apparently when the crowd gathered to try to assist this individual, they're unable to help because these door handles, they could not open them because they were flush with the doors. Tesla doors apparently are triggered to open by an auto present feature where they detect the key fob when the key fob is in the proximity of the vehicle. The key fob apparently malfunctioned. It isn't specified why, and the door handles did not pop out from their flush surfaces. The Washington Post article goes on to describe other incidents where Teslas have caught on fire. Well, the suit describes the Tesla battery as, quote, inherently unstable, and the door handles with their flush features and auto-present mechanism made the car dangerous. The decedent's autopsy, as I mentioned previously, described him as perishing from inhalation of products of combustion and death by thermal injuries. He was unrecognizable at the scene. They described it as god-awful. The only thing they could recognize on the individual was his gold wedding ring. And that's pretty much all that survived of him. The rest of it was horrible charred remains. Sounds absolutely ghastly, but that's what was indicated in the article and the description. Well, after the firefighters extinguished the blaze, the Tesla was taken to a wrecking yard, and guess what? The Tesla actually caught on fire again. So the battery conflagration had not ended. It actually continued to burn, and they thought they had extinguished the fire, towed it away, started back up again. So these batteries appear to have some sort of a propensity to self-ignite. Once again, I'll leave that up to experts in that field to make a determination as to whether that's a design defect or a product defect, or it's something that's inherent in car batteries in general, or if it's just specific to a Tesla. And you can be sure in the litigation that there will be experts appointed on both sides to address that issue. in litigation, you definitely need expert testimony to be able to testify as to such defects in vehicles. And this is a wrongful death lawsuit. It's probably a products case as well. So there are a number of factors that are going to be involved in this litigation. But I'd like to examine this a little more to give you an idea as to where I think this litigation may be going. First off, why did the Tesla lose control? We have to address that issue. What was going on here in the first place that caused him to strike that palm tree? Was it due to the negligence of the driver? Or did something break within the Tesla causing it to go out of control? Who knows? I don't know at this early stage of the litigation. I believe this accident happened in February. The lawsuit, I think, was filed October 10th of this year. It's just a new lawsuit. They may not have even filed a response of pleading at this point. Maybe they haven't even been served yet with a summons and complaint, but you can be sure they knew it was coming down the pipe. These are important facts to know. Under approximate cause analysis, was the driver's losing control of his vehicle a proximate cause resulting in the loss of his life? Well, essentially, I'm asking the question, did his losing control cause his death? Well, you could maybe make the argument, yes, it did. It's typically a two-part test that's done in negligence cases. Now, I'm applying Illinois type rules here, but proximate cause and duty, breach of duty, negligence, causes of action, wrongful death are very similar between the states. Once again, you need to apply your own state's law. This is a show for entertainment purposes, and I'm not warranting that my description is going to be accurate in the state within which you live. Well, the two-part test is a but-for test and a proximate cause test. A but-for test addresses, but for the thing that happened, like running a stop sign, for example, would the event that caused the injury ever have happened? Well, if the answer is yes, then the courts look to proximate cause as the second prong of the test. Well, proximate cause is a test used by the courts to determine how far up the timeline or chain of events that a court is going to follow before it becomes ridiculous and they're going to have to cut it off. Everything in life is a chain of events. You get up in the morning, you have a cup of coffee and some breakfast, you get in your car, you start your car, you pull out of the driveway, you back up, you put it in drive, you drive forward. Everything is a chain of events as time progresses. And you have to make the determination at what point you're going to cut that off as far as responsibility goes. In other words, is an event sufficiently related to an injury that the court will hold that event responsible for the injury? I'll give you a classic example that they gave us in law school. A car losing control and hits a utility pole. Well, it causes a blackout in a hospital maybe 5, 6, 7 miles down the road. Now, the blackout at the hospital causes one of the patients in that hospital to die because they were hooked up to life support systems and maybe the hospital's generator failed, so there was no electricity flowing to assist the patient to live, and the patient died. Well, are you going to hold the driver that hit the utility pole responsible for the death of a patient in a hospital? Probably not, because the chain of causation, it's too far down the chain. In Illinois, they use a foreseeability test. Is it foreseeable if you strike a utility pole that's going to cause a death at a hospital? Probably not. And the courts are going to look to it as reprehensible or offensive that you're going to trace that liability to the driver for that event because it's just too far removed. It's not the proximate cause of the death of the patient in the hospital. Well, in that situation, why don't we blame the parking attendant in that hypothetical? Say the gentleman or the lady that hit the utility pole was delayed in leaving the parking garage because the parking attendant was fumbling for change to give them. And because of that fumbling of change, it caused 30 more seconds of delay with the driver that hit the utility pole. And but for that, they would never have hit the utility pole because some other cause would have prevented them from hitting the pole. So we're going to hold the parking attendant responsible as well. Maybe hold McDonald's or some other restaurant outlet responsible for delaying his meal because they were slow in providing him with the meal. You have to figure out where you're going to break it in the chain of causation. And it would be unreasonable to say hold the parking attendant responsible for the death of somebody in a hospital because of a power outage for our utility pole that's hit. Well, there has to be a cutoff point. But for the Tesla losing control, would the driver have died? I would submit maybe not. So do we blame the driver? You can be sure that the lawyers for Tesla will be filing the equivalent of what we have here in Illinois as affirmative defenses along with their answer, or they may file a pre-answer motion to dismiss. Are the failing door handles a superseding cause that resulted in the driver's death? Quite possibly. I mean, that's the issue in this lawsuit. It seems clear that no first responders could get the doors open because they remained flush with the door panels. And the door handles did not present because it looks like the key fob failed or it malfunctioned. Not surprising because it seems to have been a high-speed impact. Maybe this takes away the negligence that happened to the driver during the loss of control that puts it back on Tesla, because now we've got a cause down the chain. Yeah, he's speeding, hit a palm tree, couldn't open the doors. Now that's a new cause that could put Tesla back in the hot seat again, and it actually has, because now we have this lawsuit and hold Tesla responsible because the doors wouldn't open. But there's more to it than that. When I got to thinking about this case, what about the federal government? What responsibility do they have? They approved this vehicle, did they not? It's on the road. Obviously, they approved it. They approved the design. Where is their responsibility? Well, there's a little thing called governmental immunity, sovereign immunity, and this is an old concept that goes back to England. And essentially, the king can do no wrong. You cannot sue the king. The king is above the law, essentially, and sovereign immunity. So, not surprisingly, that concept was brought here to the United States, and you cannot sue the federal government for negligence actions. There are exceptions, of course, where it's intentional or willful and wanton. Same applies for states. States have governmental immunity. Ask me how I know. A lot of cases get dismissed at the early stages of litigation unless you can show that the government had some willful intent or some malicious design. They're getting out of the case. That's the bad news. And that's a very difficult burden to meet. So federal government culpability, I think you can kind of forget that. Well, then let's look back on Tesla again. The Tesla driver's doors, were they locked at the time that these first responders tried to get them out? What difference does it make if the doors were flush or not if the doors were locked? Who cares what kind of handle it is? If the doors are locked, the guy had the air conditioning blasting, he had the windows up, they wouldn't be able to get in anyway. Doors are locked. Who cares what the door handle looks like? That's an issue that needs to get addressed. Did he lock the doors himself? Did he contribute to his own untimely demise by locking the doors? What about modern cars? I have a town car. Every time I put it in drive, start to move, my doors automatically lock. Now, I know that feature can be disabled. You got to read through your owner's manual. You can disable that feature. Do most people disable it? Who knows? I think a lot of people don't. They like the feature. They feel safer. Their doors are locked when they come to a stop in maybe a not so pleasant neighborhood. Their doors are locked and they're automatically locked. Does that put it on Ford, GM, Chrysler, and all the other vehicle manufacturers out there now because they have an automatic door lock system? The door's locked. They're not getting into my car to rescue me. Think about that. What about the battery catching on fire? I have news for you. Gasoline-powered cars catch on fire too. There's a whole history of fossil fuel burning cars catching on fire as a result of an auto accident. Look at Paul Walker, case in point. He was burned to death in that Porsche GT Carrera. I think it was a GT Carrera. He was just a passenger. Nobody rescued him. The flames were horrendous, and it consumed him and the driver, Roger Rodas, who was driving the Porsche at the time. Problem in that case, though, they had old tires, the old 10-year-old tires, which lost their adhesive or sticky grip. Tires are only good basically for like 4 or 5 years. You got to look at the tires anyway. That's an extremely important part of your vehicle as far as contact goes and stability on the road. Well, how about this? What if the car was mangled from the impact and the fenders were jammed up against the doors? And the doors, whether locked or not, you wouldn't be able to open them anyway. I don't know what the condition of this vehicle was at the time it impacted or just after it impacted the palm tree. Maybe the doors were mangled. They couldn't be opened regardless of whether the door handles presented or not. See, there are so many little details here that are going to get addressed in this litigation. It's going to be a very tough case, I believe. However, the Tesla and any corporate entity, they want to settle cases. They want to get these cases off the books. And I don't think this case will go to trial. I think it'll probably settle, but it might get dismissed on a motion for summary judgment. There's no genuine issue of material fact. The design's not faulty. It's not found to be faulty. And there was some other cause that resulted in this gentleman's death. I think that case will probably settle. Most cases do settle before they go to trial, because anytime you take a case to trial, you're going to the Las Vegas casino and you're taking a big gamble. If there's no money on the table, plaintiffs got nothing to lose by going to trial. They got absolutely nothing to lose. They're in the best possible position. I love it when there's no money offered on the table and my back is up against the wall. I'll take it to trial. I've got nothing to lose. You offered nothing. If I get nothing at trial from the jury, I'm not out anything, because you thought the case was worth nothing, so did the jury. But if there's money on the table, you may wish to consider it. So I think this possible, this litigation is not possible. It's actually happened. I think there's going to be a resolution to it, maybe not too far down the road, and it will be certainly put to bed, because it's a horrendous injury. Well, it's a death, actually, and it's an injury to the family. This is a wrongful death suit. And that's about all I have on this one. Until next time, I wish you best happy motoring and drive defensively. Take care, and there will be more later.